Okay, everybody, good evening, and welcome to the international, trying to think what the right word for this is, but the international panel, which is set up by the International Committee of this Inn. And as you know, we're going to be talking about disclosure problems. Now, very briefly, before I introduce our speakers, can I just say a bit about disclosure in international fora, in particularly international criminal tribunals? If you think disclosure is a problem in domestic work, you should try international criminal tribunals. One of the major problems is the fact that the documents that are received, particularly by the prosecution, are in the original language of the country in which the conflict, which is the subject of the trial, has taken place, and therefore need to be translated. And then in some form or another, they need to be digitalized. And that in itself causes huge problems. If I can be forgiven one more story, when I was at ICTY as a prosecutor, we had absolutely no idea for a great part of the time that ICTY lasted what we actually had, because even if translated, the digitalization of the documents was so bad that you couldn't always see what it was you had. And during the course of the Karadzic trial, which is one of the major trials of ICTY, counsel, who was assisting Karadzic, who defended himself, filed well over 100 motions or applications that the prosecution should be sanctioned for failure to disclose material, in particular material that might have assisted the defense or undermined their case. And these problems still continue today. I should add very quickly that friends of mine who are judges from civil law systems, inquisitorial ones, assert that you don't get these problems there because in a inquisitorial system, the judge gets a file, a dossier, which contains, it is said, all the evidence. Well, that is very much dependent on, obviously, the prosecution. So that's the background to what we're going to talk about this evening. Can I very quickly introduce the panelists before we move to the subject matter? Sitting to my right is Chris Gosnell, who is a renowned international criminal lawyer. Expert.
Sorry, to your left.
Oh, to my left. What did I say? To my right? Oh, thank you very much. To my left, yes, Chris Gosnell. To my right, Ben Gumpert, who has had many clients for many international criminal tribunals. He's actually an associate member now of 5 St Andrews Hill Chambers in London, originally admitted to the New York State Bar, done cases at ICTY, ICTR, and of course the ICC. He was involved in the Charles Taylor case and also Taganda and Bemba at the ICC. So that is Chris. And I should add, as I've now discovered today for the first time, he's also a double Oxford Blue, which is probably of more importance to most people. To my right is Judge Ben Gumpert, now a judge at Woolwich Crown Court, but he has extensive experience in international criminal tribunals. He served as a senior trial attorney at the ICC and led the prosecution in one of the major cases, the case of Ongwen, which was the case of a child soldier. And he also appeared at the ICTR and has been a circuit judge here since 2020. And finally, behind me, actually, I don't know if is he online?
Yep.
Oh, he is. Yes, there he is. Sorry, Simon. There is Simon Davenport, commercial barrister with significant expertise in international arbitration, civil fraud, cross-border disputes, has been a KC or QC since 2009, is a pump court, four-pump court, and his practice covers energy, banking, and infrastructure. And he's been both an advocate and arbitrator in high-stakes arbitration. And for those of you who want more information about the panelists, then you can Google them, quite honestly.
Or talk to them.
Or even talk to them. Yes, for those who are here, you'll get the opportunity to mix at the drinks at the end of the session. For those of you online, that is something that you won't get, which is an encouragement to turn up, if you can, to these things in person. So, straight away, can we start? And we will start with Ben talking about disclosure from the prosecution point of view.
Yeah, the old clicker isn't working. Well, I'll tell a funny story first. When I first arrived on... finally. Right, when I first arrived at the International Criminal Tribunal for Rwanda in 2003, frankly, not knowing the difference between a war crime and a crime against humanity, a difference I think I came to appreciate in about my third year at the ICC, sort of 15 years later. Chris Gosnell, double blue from Oxford, in ice hockey, please, was the eminence grise behind the presidency at the Rwanda Tribunal. He was a person of huge respect. We used to try and touch the hem of his garment as he passed in the corridor. Although he was, 10 years younger than me at the time. But he is somebody who, even then, really knew what he was talking about, which frankly is a rare commodity in international criminal law. And one other thing before I start, which is I want to give a shout out to that advocate who filed 100 breaches of, or allegations of breaches of disclosure. That is an absolutely wonderful American advocate called Peter Robinson, who also worked with me, or alongside me and Chris, at the Rwanda Tribunal. And if you aspire to do defense work in the international criminal field, Peter Robinson is somebody you should attempt to follow, look up, meet. Very friendly guy, but very pleased to meet you, I'm sure. Because in my view, he is the exemplar of somebody who tackled defense work in the international criminal field in an entirely appropriate and highly effective way. Right, so I'm going to talk about disclosure in proceedings at the International Criminal Court. The first thing you need to know is that the International Criminal Court does not work like the Crown Court. It works like the Crown Court used to work. That is to say that before you actually get to a trial, you have preliminary proceedings, what used to be, for those of you above 50, 60, I'm 62, an old-style committal, whereby the pre-trial chamber, bench of 3 judges, decide whether the prosecution have got a case which is worth anything at all. And so you need to be aware that disclosure at the pre-trial stage, the confirmation stage, has completely different rules to those which apply once there is actually going to be a trial. So what does the prosecution have to disclose at this early stage, at confirmation? Well, they've got to give the defense a copy of the indictment. Seems fair enough. The document containing the charges. Such was the bitter warfare between the civilistes and the common lawyers that they couldn't agree to call the charging document the indictment. That would have been an affront to French dignity. So it's the document containing the charges. Fair enough, you have to provide that to the defense. They have to be informed of the evidence on which the prosecution intends to rely. Again, seems kind of fair enough. And then finally, some morsel regarding disclosure. The pre-trial chamber may, note, may issue orders regarding the disclosure of information for the purposes of the hearing. And the pre-trial chamber has the power to take necessary decisions regarding disclosure at that stage. The pre-trial chamber has to hold status conferences, I like shall here as opposed to may, to ensure that disclosure takes place under satisfactory conditions, and a judge is appointed to make sure that happens, and the judge can respond to motions from the defence for disclosure at that stage. Where disclosure may lead to the grave endangerment of the security of a witness or his or her family, the prosecutor can not tell the defence who the witness is. But such measures shall be exercised in a manner which is not prejudicial to or inconsistent with the rights of the accused, like knowing who it is that's saying they're guilty of really serious crimes. So that's what happens before. Those are the rules about what happens before there is a trial. The judges of the pre-trial chamber listen to the evidence, summarise. Confirmation hearings usually take 2-3 days. Witnesses are generally not called, and they decide that there are substantial grounds to believe that the defendant has committed various crimes. Interestingly, just a mild diversion for just a second, the prosecution does not have control of the indictment of the charging document. It's the judges who decide what a person will be charged with, not the prosecution. The prosecution can suggest, propose, but it's the judges who dispose. And in the case of Bemba, marvellously, the prosecution decided that they wanted to charge him with some form of complicity, but the judges said, no, what you need to charge here is command responsibility. That was the judge of the pre-trial. By the end of the trial, the judges at the trial chamber were saying, no, you've charged entirely the wrong thing. We're not going to find him guilty. Well, in the appeals chamber, we're not going to find him guilty of the mode of liability which you have charged. The prosecutor said, well, we didn't do it. I didn't cut any ice. Right, so finally we get to trial. So the prosecutor shall disclose to the defence evidence which they believe tend to show the innocence of the accused, or to mitigate the guilt of the accused, or which may affect the credibility of the prosecution evidence. So this is, finally, the test which we, or those of us who practice in the Crown Court, are familiar with. It's essentially, in different words, the same thing. If the prosecution have got stuff which tends to show their witnesses are lying or confused or mistaken, or things which show that the defendant in a good light relevant to the alleged crime, then they've got to give it to the defence. Rule 77 says the prosecutor shall permit the defence to inspect any books, which are material to the preparation of the defence. So that's a broader test. It doesn't have to be something which undermines the prosecution case or which supports the case being put forward by the defendant. The test is broad, it's material to the preparation of the defence. And frankly, if you're worth your salt as a defence counsel, you can make the argument that pretty much anything which is vaguely relevant is material to the preparation of your defence. So there are some restrictions. It's just a whistle-stop tour on what the rules are, because I think it will probably help us in our subsequent discussions, in our discussion of the problem. Number one, internal work product. Your opinion as a junior lawyer reporting to the prosecutor that the case is a pile of whatever and doesn't stand a chance of achieving a conviction doesn't have to be disclosed. And then if you've got material which may satisfy the disclosure criteria, undermines the prosecution's case, supports the defence case, material to the preparation of the defence, but giving it to the defence may prejudice further or ongoing investigations, you can go to the chamber secretly, ex parte, and say, defense shouldn't have this because we're still looking at other things, other people, possibly other crimes committed by this same defendant. There are defense disclosure duties. Sorry, this is all a bit small. In theory, the defense are required to permit the prosecutor to inspect its own materials, and as long as they're intended by the defense for use as evidence at the confirmation hearing at the trial. In my experience, Chris, I'm sure, is going to get quite hot under the collar when I say this, actually what the defense consistently says, well, we haven't made our minds up yet. Actually, we haven't really decided what we're going to use at trial until about 5 minutes before we use it. So that's the way in which they get around Rule 78. And then Rule 79, somewhat ignored, in my view, by both prosecutors and defense. But in the Ongwen case, to which Joe made reference, which I prosecuted, we forced the defence's hand on this. And that requires the defense to give something vaguely akin to a defense statement, which will be a familiar document to those of you who practice in the Crown Court. You've got to say, if you're going to say, no, I wasn't there, I was having a holiday in Spain when this genocide was committed. You've got to say, if you want to raise a ground to exclude criminal responsibility, which does include insanity. They don't call it that, of course. It's having your capacity destroyed by a mental disease or disorder. You've got to disclose if you're going to rely on self-defense, for example. So the statutory defences are things which the defence are, in theory, under an obligation to announce that they're going to rely upon and to produce the materials, for example, the psychiatrist reports, if you're going to argue that your defendant is incapable or was incapable at the time of the alleged offences. Right, well, actually, I have been through the rules. This is a beautiful little scenario which I wrote, but which there isn't time for us to talk about, so you won't be hearing about Reuben Penny, I'm afraid. Let me just say a few words. How long have I got left?
About 5.
Excellent. All right. About a number of problems, as I see it, from a former prosecutor's view. The first is that, and I fear it's an increasing trend in this jurisdiction of England and Wales, but it's a terrible problem, in my view, in international criminal law. There is hardly anybody who does both defence and prosecution. You are looking at the only person who has ever both prosecuted and defended an international criminal trial from start to finish. There is nobody else in the world who has done that. Various people have floated in and out for about 3 months, doing some kind of writing sort of crazy arguments to try and persuade the judges that black is white. In terms of real independence, saying taxi rank rule, cab rank rule, I will take whatever case comes along, as long as I'm competent, doesn't matter whether it's prosecuting or defending or representing the victims. And I'm going to come back to the victims in a moment. And so international criminal law is populated by what I call true believers. Most of the people working for the prosecution believe that all defense lawyers are crooks, who are in the pay of their clients, who will reveal the moment they get hold of them, the names of their witnesses so that they can be beaten up or bribed. They believe that the defense are wholly unscrupulous, will mount any argument, will make dishonest submissions to the court at the drop of a hat, and that they are entirely in their clients' pockets. Most defense lawyers, there are some honourable exceptions, but most defense lawyers, in my view, at least a majority, are exactly the opposite of that. They believe that the prosecution are oppressive, neo-colonialist, imperialist wage slaves who are out to do down the poor and dispossessed of the world, and that they ought to be resisted by any means which is necessary because the end justifies the means. And that makes the effective workings of disclosure, whereby both parties should be trying to make sure that the court and the prosecution and the defense have got all the material they need to ensure that a fair trial happens before it starts. That kind of mentality is just completely absent. Second problem is that although I pointed you to various duties on the defense with regard to disclosure, disclosing the nature of their case, there is nothing like that. Firstly, they're widely ignored. And secondly, there is nothing like the defense statement, which is required in English and Welsh criminal proceedings, whereby the defense have to specify not only the bits of the prosecution case which they say are wrong, but also the important things which they're going to produce in evidence and rely upon as a positive defense case. So defense is routinely conducted as defense by ambush. The great advantage of the defense statement is that it enables the prosecution to make what is called in England secondary disclosure. Oh, so you're going to say that you weren't there. Where do you say you were? Okay, we'll go and investigate and see if we can find out whether you were or not. Who knows, maybe the prosecution will actually find something which supports that, which will be disclosable. There is none of that. And that, in my view, really handicaps the whole workings of disclosure. The third thing is this. We've got defense, Chris, prosecution, me. But there's somebody missing here, the victim's representative. At the ICC, there is a third party in the room, lawyers who represent the victims. They have the right to present evidence at the trial. The judges have the right, maybe the duty, to rely upon that evidence if they think it is significant evidence which might lead to strengthening the case against the defendant. What are the duties of disclosure on the victims? Any guesses? Nada. Thank you.
Yes, thank you very much, Ben. I think I'm going to put you in touch with an American lawyer called Greg Kehoe, who would assert that he too has both prosecuted a case from beginning to end and a defense case from beginning to end. But we can discuss that later. Yes, thank you very much. And we'll move now to the defense side with Chris Gosnell.
Thank you, Judge Korner. Thank you, Ben. I guess this is the clicker?
That's the clicker, yeah. But you'll need to get onto your thing.
Okay, great.
Telephone story first.
Well, sure. Well, before I get to a funny story, because there are just so many, I think I can start with just sort of a general observation, which is that one of the essential questions about international criminal justice is whether it's viable, given the degree of unevenness, polarization, and uncertainty, insecurity, frankly, that exists on the ground, which frankly is not compatible with the functions of a criminal justice system. And so this is an enduring dilemma, I think, that all lawyers and judges confront when they're working within the system. Are the minimal conditions for a fair and effective process available under those circumstances? It's all very well and very nice to say, let's have an indictment against someone who is leading a war in a country and causing widespread bloodshed and mayhem. Yes, let's launch a criminal case. Fantastic. Do the preconditions exist for having that? You know, the International Criminal Court is one of the few criminal courts in the world that is, in a sense, disembodied from the political foundation that, for most countries, is a precondition for the existence of a criminal justice system, police, legislature, and so forth. Legitimacy. And disclosure is one of the sort of areas where the rubber really hits the road on whether or not this is possible, the entire project is possible, and whether you can achieve outcomes that are good and fair. And just to understand the the problems and the reason why there are certain rules of disclosure and exceptions to disclosure that will look strange to you, we have to understand two components. And one is the volume of information that's collected in most of these investigations and the risk to individuals who have provided the information. So I want to start by just talking about some numbers that might surprise you. So from a recent case that's in the news, the Duterte case, this is an initial indication from the prosecution of the number of items of evidence. It is huge. It is eye-wateringly huge. And that's what they need to work with in terms of what they're going to figure out they need to disclose. Maybe in this case, most of it will be in English. Probably not all of it will be. There might be audio recordings, videos, all kinds of other materials. But that's the palette against which you start that makes the entire process of disclosure difficult. And by the way, they're supposed to have their confirmation of charges hearings in September. So that disclosure process is supposed to be done by August. Now, what are the scale? Before we talk about what the exceptions to disclosure are, let's talk about the numerical consequences of those exceptions, at least in respect of visible redactions to disclosable, otherwise disclosable material. And the numbers, again, are eye-watering. In respect of a specific tranche of disclosure, which is mentioned here, which is almost 6,000 documents, they're talking about 5,500 redactions. Incredible. This explains why you see prosecutors, and I saw prosecutors leaving the court at 10 o'clock in the evening on this case, complaining bitterly about disclosure. So the defense complains about disclosure, but the prosecution also complains about disclosure. And that's the reason, because they're working countless hours trying to produce these redactions and these exceptions to otherwise disclosable material. The trial chamber, in this case, made a comment that it noted with extreme concern that although the prosecutor indicated that the amount of evidence to be reviewed for the case amounted to more than 37,000 documents, okay, this is actually from another case, the amount of evidence to be reviewed for disclosure was 37,000 documents. 100 days after the initial appearance of the accused, only 1,500 had been reviewed. So that's the problem that you see even before you get to a confirmation of charges. Why are there these huge troves of information? Well, first of all, because in some cases you have investigations going on for years with no defined target. These are investigations into situations, not individuals necessarily, let alone crimes. It is a broad swath. There is no focus. You are not providing, you're not redacting documents as you go along. You can't. You don't know who the accused is. You don't know what's exculpatory yet. And because the obligation of investigation is, in theory, quite broad and onerous. It's an obligation to investigate incriminating and exonerating circumstances equally. Very much a civil law concept imposed on a large number of lawyers who frankly may be from common law systems, but who are instructed to conduct their investigations according to this fundamental principle. A third reason for the huge volumes of information is the legions of individuals, organizations, institutions lining up at the door of the ICC with enormous troves of information, handing them over and saying, here's a whole bunch of stuff you might want to look at. We're going to come to the consequences of that for disclosure, but it's another reason why there's so much information. And here's the second component of what makes disclosure difficult, the background, the context. It's risk. Risk is endemic to the situations being investigated by the ICC. Just as an example, in respect of one disclosure decision, the assessment at the beginning of the trial was remains volatile with the province where the crimes took place being amongst the most affected regions. So the example that Ben mentioned of the standard for witnesses being given protection was met for almost every witness, quite frankly, because that's the background. And the CAR is the same thing. Even in 2023, where you have some level of stability thanks to Wagner and the United Nations and other actors, but nevertheless, it's quite insecure, and that's the risk that individuals face potentially from the disclosure of certain information that otherwise should be protected. So, what is disclosable? As Judge Gumpert indicated, these are the three categories. It's fairly clear, no problem, standard. Most lawyers around the world, even from civil law systems, will appreciate and understand it. But what are the exceptions? And this is where it gets a little bit more difficult to apply. And there are three broad baskets of what I'm going to call exceptions, but they're not as such exceptions. The first is the category of exceptions that are actually laid out in the statute. The second are things that just aren't recorded or that are deemed not material, usually by the prosecutor off their own bat, quite frankly. And third is the category of things that normally would be attainable in a normal system, but because it's the ICC, which frankly is a relatively weak enforcement and cooperation mechanism relative, for example, to the ICTY, and because of other factors, simply cannot be achieved. So, exceptions. Case-by-case delayed disclosure for witnesses. There's nothing wrong with witness protection, and there's nothing wrong with concealing, from a defense perspective, concealing the identity of witnesses up until, let's say, 60 days before the start of trial. At least in my experience, that's not ideal. I would like more time, but broadly speaking, you can conduct your investigations once you have that information. And it's not too damaging permanently to the quality of the trial. One of the unfortunate side effects of these applications for witness protection are huge numbers, volumes of ex parte submissions about why those protections are required. In the Antiganda case, in which I was a defense counsel, there were 214 ex parte submissions. There was one entire hearing with a witness that was ex parte based upon the witness's desire to be heard by the judges about his particular witness protection concerns. It's a threat to the integrity of the proceedings if it's an important witness and the defense doesn't have a chance to have a look at the content of those materials and see whether or not it actually might undermine the credibility of the witness. Why? Because they're lying about their security situation. In principle, that should fall under 67(2). It should be exculpatory. How do you know in advance if they're lying? You don't. The prosecution isn't going to tell the judge that they think that the witness is lying and that the person doesn't need witness protection. And no one is going to scrutinize it in a way that's necessary to see whether or not there are elements that actually could damage the witness's credibility. So there's all these, and by the way, those submissions often are traced back to allegations against the accused. This is all about the accused and his or her current or former associates. So no problem with the delay of disclosure, but the byproduct of the process can cause significant questions about whether the defense has all the information it should have to properly test those witnesses. The second category, and this is the one that's really a bit insidious and hard to ferret out. Rule 81.3 permits non-disclosure of information to protect the safety of witnesses and victims and members of their families. So this is not about concealing the identities of family members so that the witness's identity will not be disclosed. It's about an independent basis of redaction. And the same principle applies even to a category called innocent third parties. Innocent third parties. So not a family member, but somebody who perhaps is mentioned in a witness statement, they're nearby, they see something, perhaps they're a victim of another crime. Under the redaction protocols that have been accepted by the court, and now these are routinely adopted and self-applied by the prosecutor is allowed, without further individual review, to redact the names of family members and innocent third parties where, and I quote, they are not relevant to any known issue in the case. But I suggest it's very difficult on some occasions to know whether or not such a person is not relevant to any known issue in a case. In the Ntaganda case, some family members' names were highly relevant. Why? Because they were family members of alleged child soldiers. They grew up with the alleged child soldiers. They had information about their age. The trial chamber recognized that and said, okay, this is not falling within the redactions. Prosecutor, you must disclose that. But in every case, there will be a particularity of that nature. And that is not taken into account in the standard redactions. And those redactions are permanent. They're permanent. You won't see those names. And I can tell you that the innocent third parties redaction is, thank you, is one that's been applied across the, by many different organizations. Third one, may prejudice further or ongoing investigations, mentioned by Ben. This is a huge category, and it can include NGOs, intermediaries, leads and sources, international organizations. This is all from the redaction protocol. And in addition to the identity redactions, there is also a provision that allows the prosecutor to receive information, lead information, and never disclose it. And that's 54(3)(e). Now, of course, in Lubanga, there was a stay of proceedings because the prosecutor refused to disclose certain 54(3)(e) information that was identified, and ultimately it was produced. The UN agreed. But the truth is that if it's not specifically exculpatory information, I wonder whether or not there's the same level of scrutiny of the information. Can't it just go into a lockbox and never be disclosed? If it's just material, not exculpatory. And I think there is a significant question about that. So just to quickly rush through, we won't discuss the amount of 54(3)(e) material, but it is very significant. Routine witness payments, not disclosed. We don't get them. Only if it's extraordinary, the person got relocated to Canada, tons of money was spent, okay, then you can find it out. But other things, you can't. Collateral information, which is a bullet that was meant to be added to this, notes for preparation of an expert report. Prosecution says not disclosable. You've got the report, that's enough. It took an order from Judge Korner to say, no, you have to actually disclose those notes. Things that we would consider pretty bog standard, but no, the prosecution says you've got enough, you don't need that. Quite a few things are not recorded, including, for example, interviews with minors. At least that was the practice when I was dealing with the Ntaganda case. And
when you say recorded, you mean sound recorded?
Actually audio recorded. Actually audio recorded and no transcript. So standard practice in many countries now would be, given the dangers of leading, that those should be recorded, have to be recorded. Not recorded at the ICC does kind of reflect an overall, I would suggest, mentality. So just to skip to the last point, and this is really important to understand given the expanding role of the United Nations in conducting investigations and handing over the fruits of their investigations to the ICC. We know this is happening in huge volumes. The UN has absolutely, in their own view, no obligation to hand over anything to the ICC or upon a judicial order. Why? Because they have privileges and immunities. And they also will say, we gave information based on 54(3)(e). But even if they didn't, and by the way, again, that only is supposed to apply in respect of information given for lead purposes. But when you have 55% of information in a case file or substantial volumes, you have to start to ask yourself the question, is that really what it's for? Or is it for more than that? And has 54.3e started to be abused? So the increasing use of UN information is potentially a danger. We know that this was the case for the recent arrest warrant in the Myanmar, well, they call it the Bangladesh situation. A UN witness will come into the room and testify, and there'll be a UN lawyer there saying, well, they can't testify in X, Y, and Z. Defense don't even ask the question. Human Rights Watch, their policy is not to reveal anything that underlies their reports. They also refuse requests to supply information. So those are the constraints that are around the four corners of disclosure. I know I'm beyond time, so I'll just wrap up by, I'll just wrap up by saying the big picture is dangers of outsourcing in terms of disclosure, gaps in terms of some disclosure not being there that you might expect to see, good faith failure to identify exculpatory information given those huge volumes that we were talking about, and then also the dangers posed by receiving information on condition of confidentiality, and that essentially forming a huge chunk of your case, not just exceptional lead information. Thank you.
Thank you very much indeed, Chris. And we'll turn now, without further ado, to Simon, who's going to talk about disclosure in civil cases.
Even international arbitration cases. I realise, thank you very much indeed, Judge Korner, I realise that disclosure in international arbitration at the end of a legal evening might be somewhat like spotting the dark and not the light at the end of the tunnel. So I shall try and keep this sporty and lively as best as the subject allows me to do so. But anyway, good evening. Now, completely unlike, if I may be allowed to say, the experiences of the three panelists from whom we've just heard, documentary evidence is almost always all important before a civil court, especially something like the commercial court or an international arbitration tribunal. As one judge famously said, you want to be able to see what they wrote when they were not writing for posterity. And so contemporaneous evidence in documentary form is almost always critical in deciding how to determine a case in civil proceedings. So disclosure of evidence in an international context, and that's what I'm focusing on this evening, not just in a civil context, does start from the proposition of, well, since the subject is worldwide, where are you and what are you dealing with? How do the approaches to disclosure in civil litigation differ across jurisdictions, for example, before you even get to international arbitration? So I think we can put it into a sort of trifurcation. First, the scope of discovery in, for example, US litigation is notoriously very broad. In principle, to quote one of the federal rules of civil procedure, parties may obtain any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. The information does not have to be admissible in order to fall within the scope of discovery or disclosure. This can lead to discovery being a long and very expensive process, resulting in a huge amount of material being shared and reviewed, and that's well known. Secondly, at the other end of the spectrum is the civil law countries, so say France and Spain, Germany, Austria in Europe, but also very much so within the Asian experience. So in these countries, the courts are more involved themselves in uncovering the relevant facts, and by corollary, the parties are less involved in shaping the scope of disclosure. This leads to much narrower and quicker disclosure. The parties may be ordered to disclose certain documents, but parties will not make wholesale productions of all documents relevant to the case. And in the middle, you've got jurisdictions like England and Wales. Like the American system, we're of course a common law jurisdiction, but disclosure in the English courts is, at least in principle, not as wide-ranging as it is in the States. Parties are not expected to disclose documents simply because they are relevant. There tends instead to be a focus on documents that support or undermine a particular party's position, and perhaps also documents that fall within important specified classes of documents. Lord Woolf years ago recognized that there were two enemies of civil justice. One was delay, which has been largely catered for by the civil procedural rules, and the cost of litigation, which I'm afraid to say has not been cured. And in trying to keep the cost of litigation down, there has been an overhaul of the disclosure system completely. Part 57 of the CPR Rules and Practice Direction. There's a conscious attempt to make disclosure tailored and hence more proportionate, focused on actual issues, less costly and less burdensome. And that's a critical thing to keep in mind. Right. So how does any of that translate into international arbitration? Well, the first thing is, because of the wide spectrum of approaches, you've got different platforms, you've got different parties, you've got different issues and different applicable law that the parties have chosen to apply. You might have, for example, differences not only between the parties, but also between the lawyers and the members of the tribunal themselves who have been selected by the relevant parties. For example, you might have, let me just throw this out for you, a contract governed by Singaporean law, with England as the seat of the arbitration, where it's happening, and the ICC, not the criminal version, but the International Court of Arbitration, headquartered in Paris, as the provider of the institutional rules that are going to govern the procedural requirements for the system. Secondly, you might have a tribunal made up of, say, a retired English judge, a German lawyer, and a Singaporean senior counsel, still in practice. Thirdly, you may have a Malaysian party represented, say, by Singaporean lawyers, and you might have an American party represented by English lawyers. And these are common component parts of the cocktail that goes into international arbitration. So where do you start with figuring out the approach to document production in those sort of circumstances? The starting point is to recall that commercial arbitrations only arise because the parties have agreed that they will arbitrate in the first place. Therefore, you first need to consider, well, what is it that the parties have actually agreed? So there's, in my example, there's an English seat. So what does the English law say about document production in English-seated arbitrations? Well, Section 33 of the Arbitration Act 1996 requires tribunals to give each party a reasonable opportunity of putting its case and dealing with that of his opponent, and to adopt suitable procedures that avoid unnecessary delay or expense. That gives tribunals, I would say, quite a lot of latitude, but with a warning about proportionality. Secondly, the institutional rules that we talked about are another source that might help answer the question. So under the ICC system, the rules support the tribunal having broad powers. The tribunal is to establish the facts of the case by all appropriate means. But once again, there's a balancing requirement to conduct the arbitration in an expeditious and cost-effective manner. Fourthly and lastly, if the parties had chosen, say, the LCIA rules, not the ICC rules, these are two enormous platforms and systems that govern a lot of arbitrations, then the tribunal would have similar discretion. Specific powers are given, such as to order the production of documents that the tribunal decides to be relevant, and to determine how to approach admissibility, relevance, weight of evidence, these sort of things. But again, the overarching point is that the tribunal has a very wide discretion to do as it sees fit to resolve the dispute with undue delay or expense. And it should be noted that the two narrow channels, for example, to take a decision that's been made by an arbitral tribunal to an English court, say the commercial court, is extremely narrow. And the margin of appreciation that's given to arbitrators on the ground is very substantial. It's very difficult to succeed in establishing that there's been procedural serious irregularity, such as to allow the court to intervene. So far, the parties' agreement doesn't seem to tell us too much about document production. It's got broad discretion. It's not clear whether you should expect one style of discovery or the other, Asian, US, British. So it's for this reason that the parties usually agree a system for actually administering a fair application of the rules. And the most widely used are the IBA rules on the taking of evidence in international arbitration. These rules are a set of principles that have been devised by members of the international arbitration community over various years, and the latest version is 2020. It is including practitioners and their experiences from a range of jurisdictions, such as both civil law jurisdictions and common law jurisdictions. So it's a sort of practical Venn diagram of where you end up by applying all of these sorts of principles and experiences. So usually those rules are first mentioned at the stage of the first procedural order, like a directions hearing in the arbitration. Often the procedural order will provide that the rules will be binding or perhaps will be used as guidance for determining matters of evidence. Either way those rules get used, it's likely that the tribunal will be ordering that the parties should exchange requests to produce. So a request to produce documents is the means by which they're going to be introduced. And we're going to come on to the sort of schedules which are described as red fern schedules, which I will describe very briefly in a moment. So in essence, under those rules, requests to produce need to concern documents that are believed to be relevant to the case and material to its outcome. Parties are expected to request specific documents or narrow and specific requested categories of those documents. And there's various bases on which a party might object to a particular request. Might say it's irrelevant, might say it's immaterial, might say it's disproportional, might say it's burdensome. It might say that they're raising specific issues like privilege, legal professional privilege, or extreme sensitivity, or such issues like that. A core theme in these rules is about relevance and materiality being cumulative requirements. It borrows something from the approaches in common law jurisdictions, but applies a meaningful constraint. Will the evidence actually help to resolve the dispute? Is the request likely to yield evidence that is going to make a difference at the end of the case? If you're one of those English lawyers advising the American party in the example I gave, your client might be surprised or frustrated by what is envisaged under the IBA rules. So instead of picking through swathes of the other side's files, there's likely to be a more targeted pool of documents disclosed. So really, knowing all this provides you with a number of ways to add value in the cases that you do for your clients. First of all, everything relates to the pleading that you have put into the tribunal. So you have to ask yourself, when you're drafting the pleading as to your client's case, does your pleading include the necessary hooks that you're going to need to rely on later to show that a document request concerns a matter that is relevant to the parties' pleaded cases and will be material to the outcome of the dispute? And when drafting document requests themselves, you need to make sure that they balance the expectations of precision and relevance, but also with the goal of ensuring that the documents you're aiming at will be captured. I said about these red fern schedules, this is a term of art, going back to an extremely experienced arbitrator and author called Redfern, and it all culminated in a series of columns which define a reasonable request aimed at getting to the heart of a document that should be necessary for determination in the case. So it starts with defining who the requesting party is. Does it, what are the documents that you require is the second column. The third is relevance and materiality, and you've got to state why these documents are relevant and material. The fourthly is responding party objections. The fifth is a reply to those objections. And the sixth is what the tribunal actually decide about the matter. So based on their background with the client, you may have misconceptions that you're going to have to deal with about how broad or narrow disclosure is going to be. And critically, depending on the case, and it really could be axial, it might be in your client's interest for disclosure to be particularly wide-ranging or very controlled. And that's going to lead you to go to one particular set of rules or another. You might want the US-style discovery, or you might want something more precise. If you're dealing with black letter law, you're not going to need a great trawl of what the facts are. If you want a narrower approach, you might therefore push for a different set of rules altogether. You actually can win, as it were, a war by getting in a sort of battle of forms your rules that are going to be accepted, which are going to govern play on the field. And so you might go for something called the Prague rules, which are much, much more narrowly based and going to give rise to an avoidance of any form of documents production that's just simply going to arise. It's going to be very clear that if you are pushing for something like the Prague rules, that's because you envisage that the parties are going to be perhaps arguing more about the law or arguing more about documents rather than the whole traverse of facts. Say a commercial fraud case is not going to be suitable if you're a claimant for any set of Prague rules. You're going to need the widest possible disclosure, because you're going to live in hope that you're going to be able to find what you need in disclosure, notwithstanding that you're dealing potentially with a fraudster on the other side who's doing everything possible to try and shred every single document that might be, going to give the game away. Trends. What are the trends that are emerging in international arbitration? These are interesting. The first is that there are a lot of different cultures and approaches, and they need to be reconciled. So there is a conscious attempt to try and reconcile what are different experiences giving rise to different outcomes as best as is possible. So that might be illustrated by how frequently the IBA rules are used rather than decisions being based on how disclosure operates in a particular jurisdiction. Secondly, there is a most unquestionably a trend towards openness, or at least stated openness, broader disclosure than used to be seen in international arbitration, and there are a few possible reasons for this. The first is high-tech, AI-driven, speedy document review and selectivity. Back in the day, there are two mischiefs about document disclosure. One is a document dump. Nobody's actually applying any type of SIF process. And the second problem is actually highly selective document choice, and therefore there's no fairness in the system. But now, with the use of high-tech equipment, it's very possible to get through a vast amount of material much more quickly, much less burdensome, much less expensive, and therefore arguments about disproportionality simply fall away. Secondly, most arbitrators, human point, are anxious to see that their awards are not challenged. It may be that there's difficult to challenge them, but they don't want them to be challenged. There has been a huge uptick in the commercial court seeing applications challenging awards. And I don't know whether you're all familiar with a case such as Nigeria against PNID, whereby an award by some extremely distinguished arbitrators, including former Supreme Court judges of this country, awarded an $11 billion award, which was set aside by Mr. Justice Robin Knowles in the commercial court on the basis that it was obtained by fraud and contrary to public policy. So there is a desperate desire by arbitrators, being reasonable people, not to see that their awards can be so easily arrived at by manipulation, because that is exactly what happened in the Nigeria and PNID case. A tribunal will not want it to be alleged that a party was deprived of a proper opportunity to present its case because disclosure was unduly limited. A case has just arisen recently whereby somebody turned up 2 days before the final hearing with a completely new pleading and 5 different massive witness statements. The arbitrators admitted the new pleading, and they admitted 2 of the 5 documents and excluded 3 of the 5 witness statements, one might think not unreasonably. And that is what the commercial court concluded. But it didn't stop the challenge having taken place, because there was so much money that was at stake. And lastly, many tribunals may play it safe and see it as the lesser of 2 evils to make a slightly broader document review. So those are the trends that have emerged. I don't know whether now is the time to discuss the case study, which throws up a few issues with a non-binary answer, but perhaps that comes up in the general swim of things later.
No, well, I mean, actually, I was about to say, although the programme seems to suggest we'll go in order of the speakers, I think it would be more interesting, in the light of what you said, if you dealt with your problem now. Just on a person, can I ask you, the case you just mentioned, Nigeria, is that the one where Mr. Justice Knowles accused a member of the bar of being, I do remember that one.
Yeah. Well, he stood to gain, if not hundreds of millions, billions, I think. Yeah, I think he was a relative of one of the parties as well.
Yeah. Well, I mean, I think that it makes more sense. And can I say, if we thought criminal law and international tribunals was complicated on disclosure, that sounds considerably more complicated. So if you'd like to present your problem, and then we'll start by asking Ben and Chris, how they would deal with this criminal matter, and then we'll throw in questions to the audience.
Yeah. Okay. Right. Well, it's a one-pager. I won't read it all out, but it boils down to the following. There's a sale of a company which is laudably called Green Destiny and purports to be selling ethical investments. And it's bought for $100 million by a very experienced trader in the past. And he brings an arbitration against the person who sold him that business, claiming that he'd been misled about Green Destiny's business because he found out that, in fact, it was making its money and its successful past in day trading in oil futures, far removed from green and ethical investments. So he brings that claim, and the evidence is looking good. But during the arbitration, the moving force behind the company that sold found evidence and put it forward of a tape recording of a meeting between the buyer and his family office. And in it, he's recorded as telling that he knew all the time that there must have been trading in oil futures. And he said this: "I'm not surprised. John," that's the seller, "always says how the only way to make real money is in oil, but you can call it green, then fool anybody to buy it. All that matters to me is that Green Destiny is bringing in fees." So that's our example. So he's been conned, but on the other hand, the evidence would suggest he knew all about it all along. What happens? Is the arbitration going to exclude that evidence or not? And one of the things that we threw out is that it was recorded in Germany, and in Germany, arguably, that type of evidence is actually criminally unlawful, and therefore it was illegally obtained. And after that, over to the audience.
Right. Well, I tell you what, let's start, because this is something that does actually also happen in criminal cases where you get covert recordings being made. So let's start. Ben, you're going to come back here.
By all means.
Ben, I mean, let's take this first of all, then we'll go back to the reality of what would happen in an arbitral case. But in a criminal case, what do you think would happen here?
Well, we don't have a doctrine of the fruit of the poisoned tree. The only question for the judge, in my view, would be, is this reliable? Is it what it purports to be? And if there are reasonable grounds to argue that it could be found to be what it is, it would obviously, in my view, be disclosable and admissible in the trial, despite the fact that it's obtained in a fundamentally unlawful way, if that is the case. The only thing which slightly worries me about that robust statement of what I think is that our own Interception of Communications Act means that material which German, for example, prosecutors and courts would regard as absolutely, to borrow a phrase from Chris, bog standard material, interception of phone calls, wiretaps, in other words, are here inadmissible, simply can't be relied upon, indeed can't even be considered as evidence. So the court would never effectively get to make a decision on it. So there would be a concern about that, not at the ICC, so far as I'm aware, where there is no bar on such interception.
No, well, I mean, such credit, and talking about cases here, of course, those of us, before I left my previous job at Southwark, we were just starting to deal with the Encro cases.
Encro, yeah.
Where the French thoroughly illegally set up these.
It's on our own on that one.
But of course, as you say, and I think it went to the Supreme Court, didn't it, at the end, or was it just the Court of Appeal?
Court of Appeal.
Court of Appeal, who ruled no, nothing wrong with this at all. You know, drug dealers have got to be dealt with.
Well, they ruled it was extraction rather than interception. Absolutely brilliant distinction, and of course it was so complex that nobody could really understand.
But I'm not
But
sure.
what was amazing to my colleagues, sorry,
Go on. Yeah.
was that here we weren't arguing whether these conversations between drug dealers about hundreds of tons of cocaine coming in submarines into the UK were actually reliable, whether they really were drug dealers. We weren't arguing about that at all. Nobody was disputing that this material was dynamite and was entirely reliable. We were arguing, like Jesuits, about how many angels could dance on the head of the pin, whether it was extraction or interception. And Dutch lawyers think, what are you talking about?
Yes, well, that's the Gumpert view. Chris, if this were something that you were trying to get excluded, do you think you'd stand a chance if this were a recording, say, made of your client in prison, possibly saying that witnesses might be prevented from coming to give evidence?
Mm-hmm. Well, this would almost certainly be admissible at the ICC. I can say that with confidence based on a real-world example of financial records that were obtained without a court order in flagrant violation of European human rights standards and Austrian law. And it was not excluded because essentially, and I think this is the point Ben raises, is there was no relationship between the violation and indicia of reliability. I think it's really interesting actually to listen to Simon's discussion because there's a lot of talk at the ICC about complementarity. Yes, at some level, but when it comes to rules of evidence and cooperation matters. In fact, there's, I think, a specific provision in respect of cooperation that says it doesn't matter if there was a violation of national law in procuring the evidence. Irrelevant. So, I mean, that's an interesting contrast that perhaps, in international arbitration, information production or disclosure, there's a bit of maybe there's a greater sensitivity towards national standards and conditions and requirements than at the ICC, which, as I say, at another level, has this concern with complementarity.
Okay, let's throw it open to the audience. Does anybody, Nick, I don't know, do you do arbitration at all? No.
Yeah, I don't want to.
Right. Does anybody have a view on this? Anybody? First of all, does anybody deal with these kind of arbitration matters or know anything about them? No. Well then, does anybody want to take a view on what they would do or anybody online even?
I think I would only venture the view.
No, sorry, you need the mic.
Sorry, yeah,
Nick Stewart. Nick Stewart. I just venture the view that I think in the Simon's case study, I think I'd end up admitting it.
Wow.
Yeah, I don't know what Simon's gut feeling is about that.
Yeah, it's a bit difficult to ask anybody online what views they've got. But Simon, I can say this: one of the questions that we got from people online was this: does A1 provide any solutions for disclosure problems? And from what you're saying,
AI.
you think
AI, yeah.
It really is going to make a huge difference.
Yeah, I think so. I think it's going to stop people bleating basically about it all being too overwhelming and too expensive, and it's just going to usher in a new world of being able to crunch data and crunch documentation as long as the right search words are used. And I think it's sort of process driven, and it should produce better results more quickly, and therefore allow the net to be cast more widely, without the old sin of it being timely, sort of taking too much time and too expensive.
Yeah.
Can I just ask a follow-up question?
Ben, yeah.
Back, just while it's in our
Hang on, just wait for the mic so that,
A question for Simon, if I can be that familiar. I'm from a criminal background, so this is really what I can pick up from your world that will set mine's thinking. Is there any best practice or guidance on how AI ought to be deployed to better ensure a proper disclosure result or discovery result?
Okay, that's a good question. I thought you were coming from a different angle, because there's lots of views. I think the Counsel magazine has recently had an article on it where, a great warning to not jump into AI for legal research and that type of basis. There has been already, I think, a diktat from the Court of Appeal about judges being able to use AI for the purposes of reducing factual recitations to a sort of orderly form. There's a huge sort of no-no about using it for legal research, and obviously there's been some excruciatingly embarrassing examples of people coming up with fake cases that literally don't exist in order to sort of make out a legal point. So leaving all that, what I can tell you, I think, is that I think because there's obviously ChatGPT and various examples like that, most chambers are looking seriously at the idea of being able to have a sort of their own tailored version of an AI product, which can be used for at least internally understanding where legal principles start and finish. I mean, in some ways, not totally dissimilar to something like Halsbury's Laws of England. Nobody says that you should only turn up to court with Halsbury's Laws of England and rely upon that. But it's a pretty good starting place, isn't it? It's a sort of search tool of a different nature. So as to sort of a guiding principle, I think that when it comes to disclosure, and that's what we're all talking about, which is documentation, usually the problems you've got is in a civil context is if you are getting at the crown jewels, which are people conspiring, for example, by writing emails to each other about how they're going to achieve their improper ends, they're aware of what they're writing and they're probably able to get rid of those documents. That's the problem you've got. I suppose with an AI trawl, which is going to use a systems provider, it's not going to be you as a lawyer that's going to go in there with your own sort of like Cub Scout with an idea of how you're going to apply it. You're going to actually use a service provider, a third-party professional that is going to get access to certain data and package it for the purposes of carrying out the disclosure exercise. And so the process is designed to get best out of a fair implementation of that system. And so in neutral cases where everybody's playing on side, the aim of either the courts or the tribunal is to be able to maximize the facilitation of that process within a fair world. It all breaks down in an unfair world. And that's really where it gets really interesting. Now, I think AI is going to help, because if you're a wrong 'un and you're actually trying to shred all the bad material, you actually might fail to find all the material that has left that footprint, whereas AI, properly applied, will not. So if you've got, say, in a corruption case in, say, British Aerospace, a massive company like that, they're not quite so easy to cover your tracks. So I think that AI will work very well in that situation. Where you've got smaller companies whereby maybe the amount of material is known to the wrongdoers, I think you've got a much harder job ahead of you. So generally speaking, I think it's going to help. It's certainly not going to harm. It's going to make things go quicker. And I think it's really the sort of logical follow-up to systems that have been in place already, which was to do with electronic searching and agreeing on sort of custodians and certain key search words and being able to input it into a system. And I think that kind of grew into Frankenstein's monster a little bit, but this is the sort of rationalization of it and an ability to use techniques for the purposes of keeping costs down and getting to an answer quicker. Having said that, and please don't quote me on this, everything that has been done, I'm afraid to say, by lawyers in developing out CPR and arbitration since I was practicing, and I'm about the same age as some of those on the panel, so I've been going for the thick end of 40 years, I'm afraid has only made costs go up and up and up. I somehow doubt that proportionality is going to be the ultimate winner, but we might be able to cover more ground.
Okay, Simon, thank you. I think, Ben, that's your answer in full. But, one other quick question, then we'll move to the criminal problem. One of the questions online was this: is harmonization of evidentiary norms across jurisdictions desirable or inherently reductionist?
Ooh, wow, that's quite philosophical. I think if I understand the question, I think it's clear, it's a straight yes to the first bit of the question. Is it reductionist? Possibly. But is it achievable? Probably not. And I've pretty much covered all of the possibilities there, I think.
But I mean, from what you're saying, I mean, harmonization comes through the rules of the International Court of Arbitration as much as can be done.
I agree. That's a good way of summarizing it. I mean, that Venn diagram I tried to talk about, when the parties choose the rules that they're going to apply, it's a sort of synthesis of various different systems approach to applying rules that have come from different parts of the globe over different time periods, and is a practical way of going forward on documentation. I mean, I think that what you have is that theoretically everything should get wider, but subject to proportionality. It's in some of the systems, say in Scotland, for example, back in the day, you actually had to identify what the documents were that you really needed. Well, if you're trying to find the weaknesses in somebody's cases, you're never going to know about that, because otherwise it would never have got past pre-action correspondence, because you would have been able to point it out in the first place. But because litigation by definition is the failure of common sense to intervene at that point in time, and that's because there isn't the same access to information, then you've ended up in a position that has created itself. So I think the answer is we always want to move towards a system whereby there's harmonization of what are uniformly accepted as common sense principles, even allowing for the unevenness of the road track of different systems. How it's applied is itself becomes a new game. And how you go about choosing, say, arbitration tribunal is itself really quite an important part of that game.
Right. Yes, well, thank you very much, Simon. We'll now move, because time is running short, to the problem. Both, in fact, Ben and Chris very kindly did problems, but because of the lack of time, we've persuaded them to reduce it to one. So, Chris, why don't you introduce it, and then Ben can give his views.
Well, it is based on real-world cases and situations. It involves a case against a former, let's say, warlord, alleged, based purely on violation of the right against conscription and enlistment of child soldiers. And that's not unrealistic. That was the first ICC case against Lubanga. 10 witnesses going to claim that they are child soldiers. This witness, P9, was introduced to the OTP by an unidentified NGO. That's been redacted and not disclosed. He also met a UN employee, and apparently things were written down based on their first meeting. And the notes that are contained in one document, which is a log, were given to the OTP. They have it in their possession, but the UN refuses, but it was given on condition of 54.3E, lead information exclusively. and the OTP is refusing to, or is unable to disclose it because it is subject to that restriction. They met with him extensively and probably used the log during their discussions with this gentleman, Timpson. P9 also suffered a very severe injury. Possibly he wants medical treatment. And he's also complained to the judges directly in an ex parte hearing about threats from associates of the accused. Those facts raise some challenges for the defense in terms of disclosure. And the question is, is there any way that they can get this log, which is supposed to be subject to 54.3E? So lead information only. Is there any way of getting the UN to produce it? And is there any other indirect way of getting it? Are there any unorthodox ideas about how that document could be obtained, short of theft? Can there be any disclosure of the ex parte hearing? What kind of arguments would need to be presented? And can the name of the NGO be obtained?
Actually, just on a side note, my case that I just finished trying, where we were writing the judgment, we had no arguments about the disclosure. We had no ex parte hearings, anything like that. So I don't know what went on in your cases, Chris, but they certainly didn't go on in mine.
Yeah.
Right.
Well, you ran a tight ship, obviously.
Right. Ben, let's take your view as the prosecutor. This is the application that's being made. What, if anything, would you be doing about this?
Well, I think everybody in the room needs to be clear about what 54.3E is. It's easy for those of us who practice just for these section titles to slip off the tongue. That means that the United Nations or some other body, it's not just restricted to United Nations, is it?
No.
Has said to the prosecutor, we've got a whole load of stuff which you might be interested in, but you can never show it to anybody else, including the defense, if you ever get to prosecute anybody in a situation which is connected with these documents, without our permission. This was almost everything that the prosecution collected in the early years was from international bodies. And I think, as far as I can see, the prosecutor positively went out there and said, give us everything you've got. Don't worry, we'll never show it to anyone, which was obviously a completely idiotic basis of purporting to investigate. This came to a head, as Chris said, in the Lubanga case, where, fortunately, the presiding judge was our very own Adrian Fulford. And the prosecution admitted that they had large quantities of this material and admitted that large quantities of this material was disclosable, either because it was exculpatory. I think they actually broke it down. They admitted that some of it was exculpatory, but in any event, a whole lot of the rest of it was material to the preparation of the defense. And they said, well, we simply cannot, whatever orders you, the court, make, we cannot disclose this because the UN hasn't provided authorization and we're quasi-contractually bound, and that trumps any orders which the court may make. And to give him credit, Adrian Fulford said, I'm the judge, you are one of the parties, you've got this material, you must disclose it, whatever agreements you may have made, stupid as you were to have made them. And the prosecutor came into court and had a standoff with Adrian Fulford and said, not going to. And if I had been Adrian Fulford at that stage, I would have ordered the security guards who have pistols at the ICC. That man is in contempt of court. Arrest him. But Adrian was more diplomatic. All he did was to say the constituent parts of justice cannot be reassembled in this case, where one of the parties is refusing to abide by an order made by the court, and I stay the case permanently. That's the end of it. The lily-livered appeals chamber backed out of this about 10 days later and ruled that he'd been wrong for various reasons, which I thought were garbage. Anyhow, but shocked by what Adrian Fulford had done, the prosecutor went back to the UN, who were equally shocked that the very first case at the ICC was going to fail. And some kind of bodge-up compromise was made, and the quantity of the material was disclosed. So, yes, you seek disclosure of the log. You demonstrate, I think pretty clearly here, that it is material to the preparation of the defense. You're only guessing whether it's going to be exculpatory, but it's a pretty good guess. And you say to the court, look what happened in the Lubanga case. It cannot be right that the prosecution is holding out on material without which there can't really be a fair trial. Stay the case.
Yeah. I mean, it's a problem, as both of you know, that has existed since ICTY started, because the Americans, amazingly enough, were trying to shut down, or the president was trying to shut down the ICC in one form or another, were incredibly helpful and provided satellite imagery, in particular, of mass graves or where they'd been moved. But they said, you cannot disclose this. This is for lead purposes only. And there was a lot of argument about that. And in the end, rather like the UN, the Americans said, all right, we'll let you do it. It is a really serious problem. I may say, I spoke to Adrian. Adrian, I was in The Hague at the time, still at ICTY, when Adrian was doing this. And Adrian couldn't believe it. He thought he'd done and dusted, finished his trial, was going to come back and sit in the UK, and the next thing he knew was, no, there's no such thing as a permanent stay, back you come. So, Chris, I mean, in your view and in your experience, I mean, is this stuff actually finally disclosed?
Well, I think there's two things about this problem that are important, and one is it's a log with a lot of names. The reason why that's significant is because in a complicated case, which is based purely on child soldiers, and of course it could be many other issues with a similar framework, similar scenario, you simply don't know whether something is highly exculpatory until someone has gone through it very carefully. For example, to see whether there are similarities between the names on the log and some of the prosecution witnesses. And it's almost never going to be exactly the same name. It may require looking at a whole bunch of information, biographical, mentioned in this log, that would allow someone to make an argument to say, that's the same person who's testifying they were under 15 when they joined this group, and actually they weren't. You just can't outsource that to the OTP. They just can't do that work. So that's sort of the first thing. The second thing that I think is really important here is it used to be at the ICTY that the UN supplied information in quantity. Defense counsel visited UN archives. Have a go at the boxes. That's the way it was. And now we are in a fundamental, why? Because the ICTY was a Security Council organ, not only a UN organ, a Security Council organ. The ICC is held at arm's length by the UN. We know this. They are the ones who impose these conditions, lead purposes only. Why? Because they're afraid of the security of their own people and their sources. And by the way, they have consent requirements in their own documents when they gather information. This is a huge problem because there's multiple layers of consent that in theory are required before you even get to disclosure. And by the way, how does the UN even talk about consent to a witness? The judges might ultimately say that's going to be public. They can't guarantee it's even going to be confidential, let alone not disclosed, let alone inform them who the evidence is going to be used against. So this is a thorny issue, no easy answer. I mean, I was kind of suggesting here that maybe that, if there was a very brave judge, they might come in and say, that information was never lead information only. You used it with the witness. You used it left, right, and center in your case. you violated the condition of that statutory article, and we're going to compel disclosure. And it doesn't matter that the provider gave it to you on that condition, because ultimately it's your responsibility. So this is a bit of a, you do need to start to think outside of the box in terms of potentialities, because these are big problems, and I'm not sure if the judges are ever going to be confronted with it hard, but they might be.
Well, I don't think that would be any braver decision than the one Adrian Fulford.
Oh yeah, you're right.
During my time in the prosecutor's office, the second prosecutor, Fatou Bensouda, said, no more. We're not going to take any more evidence under this condition. We need to make it plain to anybody who supplies us information that we do not have control of the disclosure process. The judges do, and if you give us stuff, it might end up being disclosed unredacted to the defence. So do you want to give it to us or not? That, in my view, was the right prosecutorial approach, and I hope that it has continued in the time that I have left the court.
I think the real problem, as you say, this ban on disclosure, it doesn't matter whether it's exculpatory or whatever. But I think the real problem comes, and has been a problem throughout international criminal tribunals from ICT onwards, is this. What happens if what has been given to you is exculpatory in some form or another, or assists the defence, you as the prosecutor, and the provider invokes what used to be called Rule 70 at ICTY, called Rule 50, whatever it is now.
2 or 3.
Says, under no circumstances. What do you, as a prosecutor, then do, Ben?
I'm afraid I haven't quite understood the scenario. You agreed when you spoke to the provider.
You, not you personally.
Yeah, but the prosecution.
The prosecution
agreed that they had a veto on disclosure.
They had a veto on disclosure. And when you got the material, you realised that it was, in fact, either really exculpatory or in some way assisted the defence case.
Well, you've got to choose, haven't you? Either you are running a case where you recognise that there may be going to be a miscarriage of justice and you just carry on and don't care, or you go to the prosecutor and say, I'm going to break my word. Sorry, gave you a promise, but I'm going to break it. You've got to choose. It's one or the other.
At which stage, all of this having in some form become public, the victims all appear and say, you can't possibly do that.
Yeah, well, they do. That's why there's so much ex parte stuff, and there wasn't in my case. But all this stuff, which when we haven't come on to the ex parte hearing yet, and actually, if we don't hurry up, we might not have time to. But you're absolutely right. There's huge pressure. Firstly, from the body within the prosecution who are for victim care before they get handed over to the registry and the victims and witnesses unit. But in my view, and I suppose you could say, well, you live in Herne Hill in London, and so nobody's going to murder you there, or it's unlikely. Whereas if you're in a village in the Congo, the risks are a bit greater. So, but I think the prosecution and indeed the victims and witnesses unit and the judges are disproportionately sensitive. There's a very good paper by a friend of mine and Chris, it's called Caroline Bousman, Dutch lawyer, about the realities of witnesses in the Congo. And she says these witnesses whose names are absolutely deathly secret. Everybody, when she went out there as a defence event, everybody in the village, oh yes, she's the one who's going to be going to talk to the ICC in 3 months. Everybody knew. Yeah. And in fact, these people weren't really in huge danger, but it suited the prosecution's book and indeed the victims and witnesses unit to say that they were. As I say, that's perhaps slightly insensitive. Undoubtedly, Ituri is a place which is a bit more dangerous to live even than South London. But nonetheless, I think there is a degree of exaggeration which goes on concerning witness safety, and it's not healthy.
Right, on which note, we're now going to throw it open to questions from the audience. This is your chance to ask these 2 experts and 3 experts, because Simon, I think, is still there somewhere. So go ahead, don't feel shy. put your hand up. You'll be, yeah, there's somebody there.
Good evening and thank you. Regarding the
Can you just tell us who you are, please?
my name's Udui Dada. I'm a student at the Inner Temple. Thank you. Just to the panel, the disclosure of the name of the NGO, would that be controversial? Because the NGO probably represents lots of different participants to the conflict. Would that be controversial in your experience?
Chris.
For them, you mean, or?
Like for the NGO.
For the NGO. I mean, the NGO normally would not want to, I mean, the basis for the redaction would be, at least in the framework of the ICC, would be a threat to ongoing or future investigations, believe it or not. That's where it falls in the redactions protocol. The idea being that NGOs like that, yes, interact with sources, interact with witnesses, provide that information to the prosecution, therefore revealing their identity may put them at risk, may put others at risk who have been or will be in touch with them. So that's the rationale behind it.
So just to ask a follow-up question, then the financial support provided by the NGO, would that be less of a risk or an equal risk?
To the witness in this
Yes.
case. Well, of course, it would not be a risk if it never gets out, if the information is not provided. The issue in terms of integrity of proceedings is if there is a perceived inducement, if the witness perceives that there was an inducement to have the medical care provided in order to claim that they were, to testify in the first instance, and secondly, to claim that they were under 15, and that information can't get to the defense, then that becomes problematic.
But, I mean, it's quite interesting, I should say, and this it did come up in my trial, that a witness was given financial support to stay in the country to which they'd taken to interview him. But all of that was disclosed. It was all in the statement.
Well, there's this clear line between what is called routine and non-routine payments. So routine payments will never be disclosed, and non-routine or exceptional payments will be disclosed. But then I think,
So, for example, the ICC or the OTP tries to give every witness, at least they did in my case, a phone, and they pay for the phone contract. And that's not revealed. That's standard routine, so that if they are indeed threatened in their home, they can ring up the local OTP contact and get some kind of help, although they're usually about 5 or 6 hours away, so the extent to which it would really be effective is questionable. So that, not disclosable.
Yeah.
I would say medical expenses also routine.
So if you have, the dividing line is medical expenses directly related to an interview, not disclosable. But if it goes beyond that, it is. But here's the problem. Registry has no disclosure obligations. Other NGOs have no disclosure obligations. If there's some sort of giving the impression to the witness that you're going to get support from a third party if you go along and cooperate with the prosecution, and that information doesn't come out, or the information is not revealed because there are inadequate disclosure rules, in my opinion, that's problematic. And if you cut off the identity of the NGO, and if you say the registry has no disclosure obligations, and let's remember, there are a lot of contacts between the registry, victim and witnesses unit, and witnesses that are just completely a blind spot for the defense. And yet the registry and prosecution are working closely together. And again, whether they're working closely together or not isn't the issue. It's how does the witness perceive these interactions, and can it lead to inducement? I am laying emphasis on this because for witnesses in the real world who are in dire straits, in very poor places, this really matters.
And let's go back to Lubanga. 8 alleged child witnesses.
Yeah.
The chamber was not prepared to accept the evidence of any of them.
Right. And in Intaganda, they only accepted 2 of 5.
Right.
That shows you how
Because there's a massive incentive if you come from a very poor village in a war-stricken area of Congo, and you realize that cooperating with the ICC and telling the OTP that you are exactly the kind of person that they are looking for, a child soldier who served under their defendant, they're not stupid people. They realize that that is going to transform their lives. And regrettably, but entirely understandably, and I bet I would do exactly the same if I was in that position, people are prepared to tell lies in order to come within the ambit of those who will suddenly be in receipt of all sorts of support because things take so long to litigate for years and years and years until the trial.
And on that note, I'm afraid we have reached the end of the seminar, but those of you here, there are, as I say, drinks on offer, and the panellists are all going to be here, and you have a chance to ask them questions. So can I ask you all, in the usual way, to thank our three panellists